we're talking about contingencies during the home sale or home purchase process. Super important. And if you or anybody you know is going through a real estate transaction, you're going to want to tune into this because you're able to get some free, I guess, legal advice. I don't even know if I could say that, but some legal counseling on the air right now. And we've got none other than Melissa Delana of Delana Law with us. She's an expert in real estate law. Melissa, welcome back to the program.
Hey, Emilio, thanks so much for having me back and for everybody listening. And yeah, you couldn't be more right. Contingencies are so important. And I think everybody knows what a contingency is as far as the general use of the term. I mean, it's, for me, contractually so important that we are identifying what's going to happen in the event of something, right? So that's really the important part of the contingency here. So we're identifying that you have a home inspection contingency. You don't have to buy the home unless you have had the opportunity to conduct inspections and all of those contingencies are satisfied. And there's a whole, I mean, we could spend hours talking about home inspection contingencies, but you and I deal with this all the time because Rhode Island state law protects buyers from being bound legally to perform under the contract until they're outside of the home inspection period.
Yeah, I mean, so in Rhode Island, there's a 10 business day time period so 10 business days, exclusive of weekends, holidays, for buyers to do all of their due diligence with inspections, and subject to inspections for information only. Does that actually hold weight? Like, can't a buyer still walk away, or is the buyer waiving inspections by saying that?
It's an excellent question, Emilio, and it's really going to depend on how the purchase and sales has been executed. So I cannot stress enough to the buyers and sellers listening at home to make sure you understand what the terms of the contract stipulate so that when you're signing it, you know that's what your legal obligations are. And if, in fact, the home buyer has waived the inspection and then is doing informational purpose due diligence, they're absolutely not going to be protected. They are going to be expected to purchase that property regardless because they waived the right to inspection. Whereas a lot of folks that I see won't waive the inspection, so they still reserve the right, but then they qualify it to say, well, this is going to be for informational purposes only, which is basically to tell the seller, don't worry, we're not going to expect you to negotiate with us. We just want to know what we're getting into. But they've still got that reservation that if they see something they can't live with, they just walk away, cite, no problem, get their deposit back, move on. And I've had sellers take issue with that because they say, well, they said it was for informational purposes only. How can they take that information and now walk away from the contract? Well, unless they waived it, that's within their right.
And the other thing, too, that I see people do is they say, oh, well, that wasn't in the disclosures.
Yes.
Can we talk about home sale disclosures?
Absolutely. Home sale disclosures are so, so important. And if you were thinking about selling your house, I want you to remember that you need to put everything down. Now, I'm an over disclosure by nature. I will share that. Yeah. But I think full transparency is the way that these transactions are intended, right? It is caveat emptor, let the buyer beware. However, where the seller has a duty to report something they knew or should have known, that is going to follow them. So what I can share with you, Emilio, and I've seen it happen, if a seller comes to me and says, oh, I forgot to mention this, or, oh, I realized that, I will absolutely recommend that they amend the sales disclosures to include that information if it is going to be considered a material fact, because a material fact is something that had the buyer known that information, it could have impacted their decision to purchase. And then you're in a place where you can't back out of it. Now, let's pull that thread. What happens if the buyer never finds out, they move forward, they buy the house, and 3 years later, that sales disclosure becomes a misrepresentation. So the fact that the seller omitted something they knew or should have known, and now the buyer is faced with damages or having to deal with the situation, they can absolutely sue the seller for misrepresentation, which is obviously not what we want. So that's where I try to explain to my seller clients, this is going to survive the closing. You absolutely need to put it all out there. Whether you think it is or isn't going to impact their decision, just err on the side of caution and disclose it. Some of the other contingencies that you may see in a transaction, of course, financing contingencies.
Mhm.
If a buyer is going to be securing a loan for purchasing, it needs to be well documented within the confines of the purchase and sales. Now, of course, Rhode Island uses a standard purchase and sales, so it's usually fine, but I have certainly seen my fair of transactions come through recently where there's no realtors involved and they're not using the standard purchase and sales agreement, and maybe they haven't developed those types of contingencies proper. Nothing can replace good legal work. And I know we talked about that on one of the last segments I was on, is ChatGPT to draft contracts is
Oh,
not going to be your best protection as a buyer or a seller for that matter.
let's talk about that contingency, subject to sellers finding suitable housing. Melissa, is that like just a blanket statement? Is there an end date? Is there a reason?
I love that you're asking this question, because forever we saw just that blanket statement. But you're right, there is no end date. If that is the only provision in the purchase and sales for contingency, you've basically just given the seller an unlimited amount of time to find a suitable or replacement property.
Yeah.
And where is there any kind of jurisdictional limit? Do we expect that the buyers are still going to be bound to this agreement if they don't find something for 3 months, 6 months, a year? What's reasonable? So most of the time, there's going to need to be a better determination of what the expectations are. And even at that, there are addendums that are populated or already available through the Rhode Island Association of Realtors that can be used that identify the time constraints. But at the end of the day, it's really got to be, what is the meeting of the minds? That's what contract law is about. What did the parties agree to? And frankly, we can modify even the best pre-populated addendums to make sure that it's going to be satisfactory for what the parties want.